Nice to meet you, Ellen. My name is Fion, and I'm here today to provide you with a clear, practical legal advice regarding to your recent purchase of the Pineview Cottage. I've understand that there are some concerns like surrounding Tina's tenancy and also David's option to purchase. And my goal today is to break this down with you and also to explain your legal positions as the registered proprietor. And also, the most important is to guide you towards the best course of actions moving forward. So let's sort this out together. Allowed me to start by introducing the Land Registrations Act 2002. It is really important as it determines your right as the registered owner of the Pineview Cottage. I'm bringing this up because it directly impacts your situations in both Tina's and David's claim. This will help us to have a better understanding whether their interests can affect your ownership or how to address this issue. So, for someone like you as a registered proprietor, the LRA 2002 is designed to protect your ownership by making your title conclusive. However, this act also recognizes that some rights like overriding interests might not appear on the register but can still affect your property. These rights are covered under Schedule 1 and Schedule 3 of the LRA 2002 and also include things like leases, easement, and also the rights of people in their actual occupations. So now let's look at the strengths and weaknesses in your claim. I will first apply Section 29, which limits the type of right that can override your registered title, making it harder for unregistered claim to undermine your title. And also Section 58, which we aim to ensure that once you are registered as the owner, your title is certain, giving you a strong legal standing and positions as the legal owner to support your arguments. However, allow me to be clear, there are still some weaknesses associated with overriding interest, which we usually call it as ITO, that may affect your arguments. These are unregistered right that can still bind you, such as like extra occupations, as I previously mentioned, where someone living in the property like Tina may have some unforeseen rights also, like for David's option to buy, but may override your ownership if certain conditions are met. So let's look into Tina's claim. Tina asserts that she has a lease agreement with Charles, which is the previous owner, to allow her to stay in the property for another 5 years. To understand more about your positions, we need to have a deep look into two aspects. So first, the nature of her lease, and second, how it impacts your rights as the registered proprietor. First and foremost, if it is indeed a legal lease, it means that it was created correctly and fulfill all the formal requirements under the LRA 2002, and also it should be typically registered. But since her lease wasn't registered yet, we should consider it as an equitable lease, which can still revise you if it falls under certain categories of the overriding interest. Moving forward, this brings us up to the concept of actual occupations, which is the main factors and also the strongest argument in her claim. So, she has been living in the room on the second floor for the past 2 years, which established her physical presence on the property. So, based on the LRA 2002 under Schedule 3 and the second paragraph, recognize that a person in actual occupations can have an overriding interest even if their lease isn't registered. So for her claim to succeed, she must show that her occupations were obvious or known. But consider that you didn't make a proper inquiry before completing the purchase, which might weaken our claim. However, we can still argue using the curtain principle to rebut Tina's claim, especially regarding the requirements of proper inquiry about her lease before the purchase. So allow me to explain what is curtain principle. This is actually a principle operates under the assumptions that a purchaser like you shouldn't be required to look beyond what is explicitly visible or disclosed on the title register. And also, you are not expected to be aware of any hidden or undisclosed interests that are not apparent from the land registry. But if the property was sold without any reference to Tina's tenancy or any indications that she had an interest in the property, we could argue that you, as the new purchaser, had actually no obligation to inquire further into her status and occupancy. So now, your positions as the registered proprietor, Section 58 of the LRA 2002 ensures that your title is conclusive, but overriding interests like Tina's actual occupations can still affect your ownership. Unfortunately, if her claim met the requirements for overriding interest, you may be required to accept her lease regardless of its registration status. But no worries, there's still room for argument as well. If her presence wasn't sufficient apparently, or if she failed to prove her interest, her claim may still not succeed. And also, the fact that her lease is unregistered works in your favor, as the burden of proof lies on her to establish the overriding interest. There are few relevant cases like Walsh and Lonsdale is a 1882 case where the court ruled that an unregistered lease could still be enforceable if the party intended to create one and possessions was given under its term. So what I want to say is, if Tina's lease was agreed upon with Charles and she's indeed being in possession for 2 years, her lease may be treated as an equitable lease, which could be problematic to you, Alan, as it might override your ownership under the Act due to her actual occupations. And also cases like Williams and Glean's Bank and Boland's and also Chhokar and Chhokar, where the court recognized that actual occupations could be a factor in determining overriding interest. These cases further support the potential risk of Tina's claim affecting your ownership. So let me to be clear, Tina's claim has the potential merit under the RA 2002 due to her occupations, but it is not guaranteed. We can still explore whether there were any lapse in the disclosure or any facts that might weaken her claim to protect your positions as the new owner. So now, after Tina, let's move forward to David's claim about the option to purchase. David claims that he has the right to purchase the Pineview Cottage, which he had entered into with Charles like 3 years ago. But we found that these options was not registered at the land registry. So what we need to do is to determine if it affects your ownership as the new owner. There are two main issues to be discussed. The first issue to consider is whether David's option to purchase constitute a legal or an equitable interest. So a legal interest is enforceable against everyone, including third party like you, without requiring registrations. But if the option to purchase is deemed as a legal interest, it will bind you even if it was not registered. However, if it is classified as an equitable interest, it would only bind you under certain conditions, like this could apply if you were aware of the options before buying the property, or if it qualifies as an overriding interest. But since it is not registered, and so his option to purchase is more likely to be an equitable interest rather than legal interest. So there are a few relevant cases here, like in the Perico of St. Lucia and Glencore 1997 case, where the court ruled that an option to purchase, even though equitable, could still bind the purchaser if it meets certain conditions. Similarly, in Webb and Poldmount 1966 case, where the court held that an unregistered option to purchase could still bind subsequent owner if the purchaser had notice of it. These cases suggest that David's option may not bind you unless you had notice of it when you acquired the property. But since the options was not registered and there is no evidence to prove that you were aware of it, it is unlikely to affect your positions as the new owner. The second issue to discuss is whether David's option to purchase is an overriding interest under the RA 2002. Certain unregistered interests like rights of people in actual occupations or those arising from legal lease can override a registered title. However, an option to purchase is not generally considered an overriding interest unless it satisfies the requirements under Schedule 3, like for example the actual occupations and also the notice, which means the purchaser must have notice of the interest at the time of the purchase, like I previously mentioned. So David's options was not registered and you wasn't aware of it at the time of purchase, which means that in general, his option will not automatically bind you unless specific circumstances apply. So overall, in short, since David's option to purchase is more likely to be an equitable interest and wasn't registered, it won't automatically bind you unless you were aware of it before buying the property. Since the option wasn't disclosed or registered, you are probably not required to accept or honor David's claim. Okay, to wrap this hold up, your positions as the new owner are well protected under the RA 2002. There is no need for concern for this. However, we still need to address Tina's and David's claim. Firstly, Tina's claim is based on the actual occupations of the property, as she has indeed been living in the property for the past 2 years, so there is a possibility that her occupations could be deemed significant enough to override your title. However, this will depends on the specific of her lease. As for David's claim about the option to purchase, we don't expect it to impact your ownership, to be honest, as the option is more likely to be a personal right and would not be registered, meaning it doesn't fall under overriding interest category. And also, there is no such evidence to support that you had received the notice of these options at the time of purchase, which further strengthens your position as well. So, in sum, there is a small potential risk from Tina's occupations, but for David's option to purchase should not affect your legal ownership. But of course, I would still recommend if we can investigate Tina's claim more closely to ensure that we are fully understanding about her legal positions. But overall, your legal standing is really strong enough. So that's all for today. Please feel free to ask if you need any further clarifications or you have any more questions. And I'm really happy to help. Thank you.